Today, you're going to learn that personal wealth is threatened by countless potential liabilities. And Ann-Margaret Carrozza will discuss some of the legal practices and protections to protect those assets. Ann-Margaret is a renowned elder care attorney in estate planning. She served as a New York State Assemblywoman for many years, and during those 14 years of legislature, she authored dozens of bills designed to streamline the estate planning process, protect seniors against consumer fraud, and expand access to quality long-term care. So sit back, take notes, and get ready to be entertained. She is a Dr. Phil contributor. She's been widely seen on TV and the internet. So we're honored to have you here.
Thanks, thank you. Good morning, everyone. It's a great pleasure for me to be here with you. And to those of you who are on Zoom, I encourage everyone to let this be an interactive session so we can target it to anything that you may have a particular interest in. I think, so much of this area, and if I had to, give it a moniker, it would be asset protection. You have estate planning, you have wills, you have elder law, but what do all of these things have in common? We're looking to safeguard what we have managed to amass during our time on this earth for our benefit, for the benefit of our loved ones. So we want to tamp down threats to what we've accumulated, and the threats are taxes, whether that's estate taxes, capital gains taxes. We want to safeguard the assets from long-term care claims. And I don't care how many millions you have, you're not going to be happy when you're presented with a bill for $16,000 a month for long-term care that was not expected. And this is especially so for so many folks who have a lot of wealth, but it's illiquid because it's in real estate or some other investment vehicle that's not easily liquefied. So we want to have a little bit of a heads up. What can we do in these various areas to protect ourselves? Not to mention garden variety liabilities, trip and fall, car accidents. We have a 42% chance of a divorce, and without some legal protections in place, we run the risk of being financially devastated. And it is a little bit ironic that, by way of background, my grandmother, I've shared the story with a few of you, was a legit trip and fall queen. She was the master of the little lawsuit. And she had a friend in Sheepshead Bay who was her doctor, and whatever she said was wrong with her, he would testify. And I guess maybe I feel a little bit guilty that my braces were paid for by some trip and falls. So I make it my life's work to get out and teach people how they can protect their assets. So let's start with what is the single most common thing. If we have nothing else, what is the estate planning document that most of us have? A will. Yes, it's better to have a will than not have a will, right? When we don't have a will, what happens? I grew up hearing an old wives' tale that if you don't have a will, the state gets everything. Did anyone ever hear that?
Yes.
Well, that was one of the many things my family was wrong about. The state doesn't get your stuff, but the state decides who gets your stuff. So imagine for a committed couple who are cohabiting and they have everything in the relationship except a marriage certificate, and one of them dies. The other partner is literally out in the cold because legally that house goes to his family members. So what we do in the legislature, many of the laws are designed to put something in place for people who don't do their own legal planning. So what we in the legislature did was, okay, if most people die, who do they want their stuff to go to? So we came up with a formula that really doesn't work for most people, I would say. And that formula is, if I die without a will, my spouse gets half and my kids get half. And that's usually not the result that we want, because what happens if the kids are underage or they have, their own issues and their own legal liabilities? So a will is very important for us to be able to determine who's going to get my stuff. But the one takeaway that I want you all to have from today is that a simple will is probably not enough. Okay, so if I have a will and I name you two as my kids, as my beneficiaries, okay, the will identifies who the beneficiaries are, but it does not lay out how should they get the assets. So imagine if I have a plain vanilla life. I have kids and they're all financially independent and they're all free from liabilities and no one has a chance of getting divorced. That's just not reality. Often we have beneficiaries who are in widely different situations. I have a daughter who went through her 4th divorce and she's having trouble re-entering the job market in her 40s. So I help her out. How does that take shape within the estate plan? So the only way we can really customize how they get what we want to give them, I would say, is through a trust. So yes, it's better to have a will than nothing, but I think there's only a small percentage of us that can rest completely on a simple will. A simple will does nothing to protect what I have from lawsuits, from taxes, and from long-term care claims. So if in my will, I say that my 3 kids get all of my assets, but between now and dying, I have the bad luck to have a long-term illness. Now all bets are off. Who's going to get my stuff? It's going to be a nursing home who gets my stuff because they put a lien on the assets. So what do we want to do to avoid that from happening? And the answer is a trust. We want a trust to own our real estate. That is just a bottom line. There are very few things that are black and white in the law, but I would venture to say that having a trust own the real estate is black and white, because at the very least, we want our family to avoid having to go through probate. Okay, you've all heard that term, probate. Why do I have to go through probate? I did a will. I did a will with a lawyer. I paid them money. Why do I have to go to probate? It's sort of interesting historically, but the probate process has changed very little in hundreds of years. So whether I have 100,000 that needs to go through probate, or I have 10 million that needs to go through probate, the process is largely the same. And probate requires that all of our heirs at law, that's the estranged child that we haven't spoken to in 5 years, everyone who could have a legal claim, whether they're included in this will or not, they must be officially notified. They must be served with process. And if I'm cutting a child out, there'd be no reason for them not to show up at court with a lawyer that they're paying on a contingency fee basis to, try and break the will open, and the people who are in the will are going to be well advised, give them a settlement to make them go away. So if the goal is not to have to give them 50,000 to go away, we want to avoid having to go through probate. So if I have a single family home, I want that home to be owned by a trust. And what that does is it enables whoever I want to take it upon my death to be the beneficiaries of the trust, so that the moment I die, boom, the property becomes theirs. And it's the same model as if I have a CD at the bank with beneficiaries on the CD. All my named beneficiaries have to do is go into the bank with a death certificate, and they walk out with a check. So we want that to happen with the real estate, that it goes to them automatically. The question is, what type of trust do we want to have? And what are the two basic kinds of trusts?